Further hearing in the appeal on Regency Villas Title Ltd and others against Diamond Resorts Limited and others.
The second of the three cases conferring economic benefits, or attempting to do so, is Clapman and Edwards. You have that at tab 3, page 804. As on this case, the appellants actually endorsed a paragraph of our written case, 171 on page 308, as well expressed. I can take this shortly. You will recall that the covenant was construed as not restricted to advertising the petrol station, which was the dominant tenement, and its products. We have submitted that were it otherwise, the result would have been different. A useful point to note on the facts is that the petrol station owner pursued the economic logic of that and actually purported to grant to a bill posting business, borough bill posting, the right to advertise on the flank walls, and it was that that provoked his landlady and the servient tenant to seek an injunction. So that aspect of the facts brings out very clearly that use of the billboard was unrelated to the normal use and enjoyment of the petrol station. So, to adopt my friend's example from yesterday, advertisements for Coca-Cola could have appeared thereon. So the result in that case, we submit, was unsurprising. And the third is the New South Wales Court of Appeal case of close farming, which you have at tab 11, starting at page 1018. If you would turn, please, to page 1019, I think it would be helpful if you would be kind enough to read to yourselves the head note down to the end of held number 1, so that's 3 lines on to page 1020, if the court would be so kind.
I think we did read most of this yesterday.
I'm so sorry, I checked. I wasn't sure you'd been asked to read it, but if you're familiar with the case...
Or maybe some of us did so anyway.
Yeah. Well, that's very helpful. If I can take that as read, there are then a few limited sentences only, as my friend obviously cited a number. Page 1024, paragraph 31, please. We have, in the 4th line of paragraph 31, the judge's finding of fact. As Justice Bryson concluded that where the right granted accommodated and served the dominant tenant depended on whether the right granted was connected with the normal enjoyment of the dominant tenement, that is a question of fact, dependent on the nature of the dominant and tenement and the right granted. Drop 4 lines. Justice Bryson concluded that in reality the 14th restriction did not accommodate Lot 86 as a piece of land. This was because he concluded that there was no evidence supporting any accommodation, advantage or enhancement of Lot 86. Thus, Lot 86 could be a convenient incident to action under the 14th restriction, but that is not enough. And on over the page to 1025, paragraph 34, line 3, line 4, the last word is but. But this is provided that the conduct of the trade is a necessary incident to the normal enjoyment of the land, not merely, key phrase, an independent business exercise. The respondents submit, and I read part of this because the paragraph ends with the words, I would agree. The respondents submit, drop 3 lines, that it was merely a convenience and matter of efficiency that Lot 86 be used for the purposes of farm management. Secondly, no feature of Lot 86 rendered it the natural only place from which to carry out harvesting and associated works. To the end of that line, there was no evidence which indicated that farm management, as distinct from storage, was actually carried out on that lot. The supposed connection was thus not a real one. And going back to page 1021 for paragraph 8, which wasn't originally read but was referred to in answer to Lord Carnworth's question, when the last sentence says, at all relevant times the lot has been used for storage of farm machinery, at all relevant times must be a period of somewhere between 10 and 20 years, because it would run from the 1980s, in the second line, through to 2000, when we see paragraph 21 in effect, the dispute broke out. So for a substantial period of time, the position was as stated at the end of paragraph 34. Hence, at paragraph 1026, when Justice of Appeal Santo, rather than focusing on submissions and what was stated by the judge at first instance, gives his own summing up, as he puts it in the heading above paragraph 40. Second line of 43, the appellant was unable to establish that the connection between the land and the industry carried out on the land was more than just a mere convenience, as required to establish the requisite accommodation. Over the page, top of 1027, third line, any supposed connection between lot 86 and the supposed servient tenement went no further than to render the latter but a convenient incident to the exercise of the right, were it exercised at all. So my learned friend dealt with paragraph 44, so I won't repeat that, and he complained that we hadn't answered this case specifically in our written argument, and queried how we distinguish it. And we distinguish it in these three ways. One, in our case, the trial judge found that there was the necessary connection. Trial judge paragraphs 41 to 42, so that's a fundamental distinction immediately. Second, in our case, there was a genuine connection between the Regency Villas and the Broom Park estate. The evidence from both parties below showed that the rights were indeed exercised by those occupying the Regency Villas, the dominant tenement for the time being, unlike lot 86 in this case. Thirdly, in no way was the vesting of rights in the Regency Villas a mere convenience or artificial retention of land so there was a dominant tenement to enable it to be exercised by people who were making relevant use of any land in the area. That is how we distinguish the case of close farming. At page 307 to 308, in our written case, paragraphs 168 to 169, we draw attention to the important judgment of Mr. Justice Warren in the Polo Woods Foundation case. Given that we have drawn attention to a number of points in writing, might I simply give you the electronic page references to support the sub-paragraphs there. So 307, paragraph 168A, paragraphs 37 to 39 are to be found at MS 945. 5 lines in, Ellenborough Park 169 is MS 862. Over the page, sub B, paragraph 39 of Mr. Justice Warren, MS 945, and paragraph 53 of Mr. Justice Warren, this is C, running through to 53 to 56, is 950. There are, looking at it again, two further points in the judgment that perhaps deserve to be a D and an E, so if I can simply identify them for you. Mr. Justice Warren dealt specifically with the concept of normal enjoyment at pages 944 to 945, paragraphs 35 to 36, and to the concept of benefit at page 948, paragraph 46 to 47. We did deal on page 293, going back slightly at paragraph 149, with the five-part taxonomy offered in the grounds of appeal. But I noticed that we failed specifically to deal with the revised three-part version to be found on page 206 in paragraph 151 of my, paragraph 51, I'm sorry, of my learned friend's written case. I can deal with that very shortly. We say that the missing facilities, quote unquote, explanation for a number of the cases is artificial and not helpful. Subject always to that, we say that if any of you members of the court were to find that a helpful heading, we would say that 26 timeshare units built in close proximity with no right of access to any of the recreational facilities around them would be rather a good example of a missing facilities case. And in any event, it would leave them probably in breach of planning control in even using their units at all.
Sorry, I don't understand that one.
Your Lordship will understand it if I'll take it out of order. I was going to give 5 points answers to questions to finish. First, can I take you again to page 446?
Come to it if you want to.
We are coming to it, I
Yes.
promise, my Lord.
It was just the breach of planning control.
Yes, I take it first, that's fine. I've got 5 points by reference to questions and things that come up yesterday. Let's take planning control first. At page 446 is the outline planning permission for Regency Villas. And I failed to see when I addressed you yesterday and referred to it briefly that the pages are, in a sense, out of order. So if I could just show you it again, because I don't think I did this justice. On page 446, we have the start of the planning permission with the first 4 conditions, which have Roman numbers at the bottom of the page. What one should then do is skip a page and go to 448, where planning conditions 5 and 6 are to be found. And planning condition 6 is that the residential accommodation hereby permitted shall only be occupied as accommodation ancillary to the principal building, Broom Park, being occupied under the applicant's timeshare scheme as proposed in association with the principal building. And then on the left-hand side at 447 are the grounds for the imposition of the conditions, and the ground for number 6, which I did refer to in substance, is that the site is within an area of great landscape value where new dwellings would not be permitted but for the special circumstances. The lawful occupation of the 26 units would depend on compliance with condition 6.
Yeah.
I failed yesterday to spot that the pages were out of order, and I don't think I dealt with that very clearly, so I apologise for that.
Well, you didn't draw our attention to the grounds.
I didn't, no.
No, you did to the condition.
Secondly, I realised that in my haste to make progress, I skipped mentioning the case of Duncan and Louch, which we cite on page 278, tab 20, it's at tab 26. I can simply deal with it in this way, that we submit that that case was correctly analysed, both at first instance in Ellenborough Park at 837 to 839, and by the Court of Appeal at 877 to 878. Third of my 5 points, in stating in his submissions yesterday that the servient land in this case was a public facility and agreed to be such, my learned friend was overstating the position. It is not public land, it's a private facility for which individuals can pay for entry, either through membership of a relevant club or by paying a one-off fee charged to members of the public who seek to be admitted in return for payment. It follows that the servient owners can control who is or is not allowed onto the servient land, impose limits as to numbers if they find that necessary, and so forth. Fourthly, my Lord Carnworth yesterday, by reference to paragraphs 65 to 67 of my friend's written case at 209 to 210, asked about a passage in the Law Commission consultation paper about, in particular, the contrast between restrictive covenants and easements and the availability for the former but not the latter of a statutory mechanism for discharge or modification and so forth. There are, in fact, a number of relevant references to that. I'm obliged to Ms. Longstaff for digging these out for me overnight, and we can provide copies of the relevant pages by PDF later. The consultation paper itself dealt at paragraphs 14.24 and 14.32 with the proposed extension of the Section 84 jurisdiction to easements. Those are internal pages 235 to 237. The Law Commission report did pick up on that, and at paragraphs 7.27 to 7.35 recommended that such an extension be made. That is internal pages 162 to 164.
Do you have MS numbers for any of this?
No, that's the point, my lady, that they're not in the bundle,
I see.
and we will provide them in a PDF clip.
Well, I think it would be handy.
I understand. I've been given these this morning, my lady. So. Thirdly, so far as electronic searching, including petition, in particular the Commission's site, go, there has not yet been a government response to that proposal with regard to easements. There was a 2017 white paper with regard to housing, which responded to some restrictive covenant-specific matters, but there doesn't, that we can find, hasn't yet been a government response to that specific proposal. Fourthly, Gale, current edition, which is 2017, supports the recommendation at paragraph 1-157, page 86 of the book. McGarry and Wade notes the recommendation in two places, 28-037 and 29-007, pages 1296 and 1328, without expressing a view either way. Gray and Gray doesn't appear to deal with it, but the most recent edition preceded the report anyway. So,
what was the date of the Law Commission's report?
The report, 2011, the consultation paper, 2008. So Gray and Gray couldn't have dealt with the report anyway. So those are the answers to Lord Carnworth's questions. Finally, Lord Briggs asked in respect of the date on which one considers the nature of the dominant tenement. I can provide these references. We deal with this, page 309, paragraph 173 of our written case. Judge Pearl dealt with it at page 393, his paragraphs 23 to 4, and page 397, his paragraph 41, and we support what he said. It's dealt with in Ellenborough Park, and this is the one I'll ask you to open just so I can identify where on the page it's dealt with. Firstly, MS 866, Report 173, that you'll be familiar with now, but it's tab 5 for the record. And it's about 15 lines down that page, immediately after the reference to it being a question of fact, accommodation being a question of fact. He says, as to the former, so that's the nature of the dominant tenement, it was in the contemplation of the parties to the conveyance of 1864 that the property conveyed should be used for residential, etc. purposes. And if one looks back to page 857, or report page 164, in the quotation from the conveyance on the penultimate line of the page, the buildings are referred to being now in the course of erection. And then it's dealt with in Moncrief and Jameson. I'll just give the references if I may. That's at tab 6. Lord Hope deals with it on page 884, paragraph 7, and page 891, paragraph 30. That will be immediately obvious if one looks at them. Lord Mance touches on it at page 916, paragraph 102, by using this phrase, contemplated use. And Lord Newberger deals with it at page 922, paragraph 132, using the phrase anticipated use. Secondly, a number of my friends' submissions about this were put on the basis of facilities to be provided in the future. If you look at page 173, please, for paragraph 14 of the Statement of Facts and Issues, it starts with this word, at the date of the grant. So the matters listed there already existed at the date of the grant. They weren't things that came into existence in the future. And if you look at the end of paragraph 14 on page 174, after the reference to the diagrammatic plan, it says the judge at first instance had before him in closing a table summarising evidence given in respect of the facilities over time, the contents of which were not disputed nor expressly admitted, either before him or in the Court of Appeal. And if you go to page 467 for that table, in particular in relation to the golf course, which was one of the last things certainly to be completed, we see on page 467 that the evidence of DB, that's a witness Delith Burtonshaw, called by the appellants, the golf course was officially opened in July 1981, and the reference is given to the paragraph of her witness statement and cross-examination. So this is not a case of what happens if these facilities are not provided in the future. If one's going to look at the future, it's the hypothetical question, what happens if they're not maintained? But they were there at the time of the grant. So I move on to mere passivity. Although my friend included in his submissions an assertion based on, if I may be forgiven saying so, a sort of chop logic exercise, he asserted that it was common ground that these rights do require more than mere passivity. That is certainly not the case. Page 321, paragraph 199 of our written case. There is a very helpful summary of the law given by Lord Justice Longmore in Carton Cole, paragraph 8, which, given the constraints of time, I would invite you to read. It's in paragraph 184 of our case, electronic page 313, or it's at it's in the volume 6 of the authority, so this is a supplemental page number, and the judgment is supplemental page 3 and following. The key paragraph is supplemental pages 5 to 6. It is by no means unknown for easements to be granted over land which includes facilities which inevitably require maintenance. And I would draw your attention to 5 examples of that and start, if I may, with one of the older cases. I don't think it's an exaggeration to call it a seminal case, tab 53 in volume 3, electronic page 1573. And this is the one which I actually ask you to open. Got the years right. The King's Bench decision is 1698 and the appeal in the Exchequer Chamber is 1699. It isn't immediately easy to follow how the report reads, which is why I'll just take a couple of minutes to hopefully help you with that. So on 1573, about 8 lines from the bottom of the page, if a lease be made of a house and piece of land, except the land on which a pump stands, with the use of the pump, the lessee may repair the pump, but no action of covenant lies against the lessor for not repairing it. And then the covenant is recited. We see the first to second lines on page 1574. The grant included the use, and it's put there, occupation of the pump. The first and only new paragraph on that page refers to 3 of the 4 King's Bench judges who gave judgment the other way around, as it were, in favour of the plaintiff first time round. Page 1575 at the top, we have the dissenting judgment of Justice Twisden in the King's Bench, and that's important because it becomes the reasoning of the appeal court for reversing the decision. And he says in the 6th line of the page, but in this case there is no misfeasance but only a non-feasance for which no action lies, over to the next page. As in the case where I grant away over my land, I shall not be bound to repair it, but if I voluntarily stop it, an action lies against me for the misfeasance. but for the bare nonfeasance, viz. In not repairing it when it's out of repair, no action at all lies. Over to the next page, 1578, line 3. In this case, the plaintiff himself, being the lessee, might have repaired the pump, for although neither the soil itself nor the pump be granted to him, yet, by the grant of the use of the pump, the law has given to him this liberty, and then emphasised in italics, for when the use of a thing is granted, everything is granted by which the grantee may have and enjoy such use. Then on to page 1580, at the top, presumably the words of Saunders, a rather opinionated law reporter, then treats us to this. But notwithstanding his opinion, that's the dissenting judgment, which was much the better one, as I thought, judgment was given for the plaintiff. But afterwards, the legal term identified, the judgment was reversed in the Exchequer Chamber by judges listed for the matter of law only for the reasons in the dissenting judgment below. So and that case is cited at one place in Carter and Cole. It could actually be cited in support of Proposition 5 as well. Now, given the constraints of time, I will identify for you with references the other 4 examples of land with including facilities which inevitably require maintenance. So the lock and sluice gates in Smith and Godmanchester. You have that case at 1672, the Court of Appeal report at 1672 to 74. That, I'm sorry for those of you using tab numbers, is 60, is better for the facts at 1672 to 4. It's in the bundle for the well-known dictum of Lord Herschel, then a Lord Justice of Appeal, at 1676 to 7. The head note of the House of Lords decision at 1681 provides a convenient summary of the well-known outcome of the case, and there are relevant passages in Lord Watson at 1684 to lower 1684 to the top of 1685, and then lower down on 1685, and we have something on the top of 1686, which is Report 701. One paragraph of Lord Davy, I think you would find helpful on page 707, which is electronic page 1692, the second new paragraph on that page. The third example is Ellenborough Park itself, the pleasure ground obviously requiring some maintenance, and we've already seen that the Master of the Rolls drew attention to that. Electronic page 861, report 168, and electronic page 869, report page 176. Fourth example.
But in Ellenborough Park, there was the easement was conditional upon the communal owners funding
Yes.
the cost.
So as to the funding, there was provision for contribution. Certainly there was. But it was still the case that the nature of the servient tenement was such that it would require maintenance.
It was.
Certainly. I accept there's that distinction of fact, my lord, yes. Fourthly, lavatories, again, Miller and Empser, in particular at electronic page 1513 at the foot to 1514. That's report pages 315 to 316. I'm sorry.
Sorry, could I have that again?
Yes, Miller and Empser, it's the lavatories case. I should have said it's tab 46, therefore it's in volume 3. The electronic page numbers are 1513 at the foot of the page through to 1514, and it's also can be noted that in argument at page 1511 of that case, counsel referred specifically to the distinction between the apparatus, as he put it, and the room as a whole. And the fifth and final example is the airstrip. That's Doughty, Bolton, Paul, tab 24, therefore in volume 2, electronic page 1192. In addition to the head note on that page, the relevant passages are on 1202 to 1203, Lord Justice Russell report 23D to 24D, with express agreement of the other two judges on 1210 between 31D and F. Turning then to the nature and extent of the ancillary rights, at page 317 in paragraph 190 of our written case, paragraph 190, electronic page 317, we deal with the nature and extent of that right. In the fifth line, the grant carries with it the right to enter on the appellant's land, but only within limits, to do any necessary work in a reasonable manner. And in footnote 87, one of our references to Gale, paragraph 1-93, and I would just ask you to look at that. That's in tab 71, so that's volume 4, and it starts at page 1820. The particular words I would read out are on 1821, line 4, but only to do necessary work in a reasonable manner. And then about 7-8 lines further down, the extent of the ancillary right has to be determined in the light of the particular circumstances of the grant. It is not limited to the minimum standard to make the grant effective. So I think are the key elements to place before the court. So we submit in short that bearing in mind that that is the extent of the implied entitlement to maintain in the absence of maintenance by the servient owner, what the Court of Appeal said on page 381, and in the relevant paragraphs are 76 and 78, when you read those two paragraphs together, and don't just take the last few words of paragraph 76, the Court of Appeal approached the matter correctly. And in particular, at the end of the Court of Appeal's paragraph 78, we would respectfully adopt and commend to the Court these phrases: a working golf course, and in the last line, maintain it in playable condition. You have, back on page 267, in the rather lengthy footnote 22, a number of materials about what the essential elements of golf are in terms of land.
But I think we know that.
Yeah. Well, my lord...
I mean, the question is here is not, one can obviously play golf in all sorts of places, but this is a championship golf course, which entails all sorts of services over and above simply maintaining a grass where you can sort of hit a ball. And that seems to me the real difficulty, and I don't know what the answer is, but where one's talking about not just simply maintaining some land or a garden or whatever it may be, but actually where the services are an inherent part of what you're paying, what you're expecting. How does that fit into the cases?
In my respectful submission, it fits in this way.
And this is really what Lord Scott had in mind.
Yes. It is very important that at the time of the grant, for better or for worse, the championship course was formed. So no question about course design, how long the 14th will be, all that bunkers. You start with an actual golf course. Then you consider, and suppose the owners then do nothing about maintaining it at all, what the use of the right summarised by Gale at paragraph 1-1.
No, I understand the way you put it. You say...
Could I hear the end of the sentence?
Our case
I don't understand as much about golf as everybody else in this room.
No,
I understand
Everybody has a similar understanding to me, I think.
Yes.
If you apply the implied rights that Gale sets out at paragraph 1-93 to that pre-existing golf course, what one would be entitled to do would be to do what was necessary to maintain the 18 teeing grounds. One would need to maintain the 18 holes, and one would be able to have to do enough mowing or grazing of goats or sheep, as it used to be in St Andrews and so forth, in order to make the course playable. what I respectfully submit Gale paragraph 193 would not entitle one to do would be to send on excavators, teams of groundsmen, teams of greenkeepers and so forth, all as ramped up or exaggerated by the appellants for the purposes of then turning this into an ineffective grant. My Lord, that is how we would put our case.
So you reject the suggestion that it's necessary to appoint, or even possible to appoint, a course marshal or staff or caddies or buggies and all the rest?
Indeed. And the fact that what was there in November 1981 opened 4 months earlier, July 1981, was maintained at that stage to a championship grade course does not mean we're entitled to do all things one mentions. And there are, I know, many users of municipal golf courses who are not used to the level of manicured precision that perhaps those familiar with Broome Park are. I ought briefly to divert from golf to swimming pools, just so that I've said a word about Lord Scott's dictum at paragraph 47, page 897 in Ellenborough Park. I will substantially rely on our written submissions. So, page 319, paragraph 194 is where they start. We respectfully endorse what Judge Pearl said, page 401 to 402, paragraphs 62 and 64. A tanker would be one way of filling a swimming pool. A hose running from Regency Villas would be another. We respectfully endorse what the Court of Appeal said on page 380, paragraph 72. And we respectfully endorse the academic commentary on Lord Scott's dictum, which we cite at page 320, paragraph 195 of Mr. Clark, and the authority itself, it's an extract from the All England Annual Review, is tab 84, so that's therefore the last tab of volume 4, pages 1957 to 1958. Now, Moncrieff and Jameson was, of course, not a case about swimming pools. If it had been, and the parties were expecting Lord Scott to opine on swimming pools, they would have been able to cite the earlier British Columbian Court of Appeal case about them, Grant and MacDonald, tab 105, page 2125, which I showed you yesterday. And there's a short, and we say helpful, case note about that case, showing the international nature of private law these days in a New Zealand conveyancing journal about a British Columbian case, and it's tab 115, page 2247. For those reasons, at page 321, on page 199, we submit that the grant properly construed does not require more than mere passivity. The next topic is ouster. On page 321, at paragraph 201, we refer to the fact that this is well established to be a question of fact and degree where the decision of the trial judge is normally determinative. The authorities we cite are Platt and Crouch, a relatively recent decision of the Court of Appeal. The electronic page reference for paragraph 45 there is 1569. The case itself is to be found at tab 52 and therefore in volume 3. Similar statements may be found in Gale, paragraph 1-66. I'll simply give you the reference if I may. It's electronic page 1811 in tab 71. And McGarry and Wade, it's paragraph 27-020, which may be found on electronic page 1863.
Sorry, page?
Electronic page 1863.
Thank you.
That's in the McGarry and Wade one. The learned friend invited you to assume in our favour that Lord Scott, on the test proposed by Lord Scott on page 904, electronic page 904, so that's the report report 2643 letter B is the easiest way to identify it on paper, and therefore that says that you have no need to decide whether the Judge Paul Baker QC test applied by the agreement of both parties, not by otherwise the ruling of the court in Batchelor and Marlowe, was correct and survives the criticism of Moncrief. Now, we also say that you have no need to decide that point. We say that at pages 330 to 332, paragraphs 225 to 232, and to encapsulate that in a few words, we say that because whichever of the possible tests which we review in those paragraphs, there is no way on the facts of this case that any ouster is involved. May I just give you one correction while I'm there? In paragraph 228 on page 331, we give a cross-reference to paragraph 176. That's wrong. It should be a cross-reference to paragraph 191. We submit page 322, paragraphs 202 to 203, that the trial, there's nothing wrong with the trial judge's findings here. If I might briefly show you those at page 398, please, starting at paragraph 46. I won't read it all out, you'll be relieved to know, but at the end of paragraph 46, if you could perhaps be scanning what he's saying while I speak, I read the last sentence, 46. This confirms that the defendants are in a real sense in possession and control of the estate. In 47, he acknowledges that proper restrictions and regulations made in the ordinary course may be imposed by the servient owners. At 48, he refers to there being many examples of easements which cannot be simultaneously enjoyed by all dominant and servient owners, the most prosaic example being a toilet. And at paragraph 50, he rejects the joint possession submission in the fifth line of paragraph 50, saying they have in no sense been ousted, and their ability to exercise ownership rights and to remain in possession remains. Paragraph 51 in the middle, the defendants are not prevented from altering the layout of the estate to its best advantage, and there have in fact been many alterations and additions. They are not sharing joint possession, but control the site and manage the various facilities, including the determination of opening and closing times. We submit there is nothing legally wrong with those findings, let alone are they, quote, plainly wrong, as the Platt and Crouch test put it. There's no basis to submit that those paragraphs set an insufficiently stringent standard so as to disadvantage the appellants. And indeed, if one looks at the appellant's written case at paragraphs 108 to 111, you will find no criticism of the judge's approach or findings on this issue, and indeed paragraph 101, electronic 219, we say, tends to support them. That should be an end of the appeal on this issue. If you're minded to go to the Court of Appeals version of the findings of fact on the, if I can call it, the unpacked basis for short, then we deal with that on electronic page 322 in our paragraph 204. And again, submit in essence that those findings are clear and that there's nothing wrong with them in any legal sense. If you would turn to that briefly at page 378, please. It starts at, the relevant section starts at paragraph 60, and then the particular sentences would be under the heading for the tennis courts, which is at the bottom of page 378. On page 379, the last sentence of paragraph 66, if they close such maintenance would, as we have said, certainly not involve actual or even shared possession of the courts. Paragraph 68 about squash courts in the middle, starting 4 lines in, there is no need for shared or actual possession or occupation for the claimants to be allowed to use the squash courts. If the defendants closed their business and allowed the courts to fall into disrepair, the claimants could repair them, again without taking shared or actual possession or occupation of the land. Paragraph 70, the putting green and the croquet lawn, lines 3 to 4, same reasons as for tennis and squash courts. Lines 6 to 7, the claimants could themselves mow the lawn. 380, the swimming pool, you're familiar with that, I've referred to that, in particular perhaps the end of the paragraph 72, simply providing the necessary water or even one's own filtration plant cannot be regarded as sharing possession of the land on which the pool is constructed. And paragraph 78 with regard to the golf course. So taking paragraph 78, page 381, 5 lines from the bottom, but in our judgment there is no principle that prevents the grant of a right to use a piece of land formed into a working golf course from being valid. We do not think it would be necessary for the claimants to take actual or even shared possession of the land on which the course was laid out in order to mow it and maintain it in playable condition. Interestingly, what the appellants say in paragraph 113 of their written case on page 222 is that the Court of Appeal were correct as far as it goes, as far as its judgment goes. And their complaint in paragraph 114 on page 222 is not that the Court of Appeal applied the wrong test or too lax the test, but simply an attack on the answer with these words, "It was wrong." An attack on the answer to a question of fact is no basis for this court to interfere with what either the trial judge or the Court of Appeal said. We respectfully submit that strong, if insofar as you are lured into reviewing those findings, there is strong support for them in the fact that ground of appeal 3 is specifically founded on the exercise of the ancillary rights, yet, as we've already submitted, it's paragraph 213 in this section, but it echoes paragraph 190, to which I referred you a few minutes ago. If one takes Gale paragraph 1-93, almost by definition or ex hypothesi, the action will not be excessive, because the ancillary right is limited to doing what is reasonably necessary in the circumstances. One case mentioned in this section, which I ought briefly to deal with, because there was a judicial question about it yesterday, is the case of Jones and Pritchard, and in particular the well-known dictum in it. This case is at tab 43, so that's in volume 3 for those dealing with it on paper, and in particular at electronic page 1454. I'm sorry, it's 1453, my mistake, I'm sorry. And it's what's not actually a case about a bridge, but it's a very famous dictum about a bridge. So on page 637, it's Justice Parker, and two-thirds of the way down, the paragraph starts in the next place. He refers, as we're now familiar with from Pomfret and Rycroft, the owner of a servient tenement is not bound to execute any repairs necessary to ensure the enjoyment or convenient enjoyment of the easement by the owner of the dominant tenement. The grantor of a right-of-way over a bridge is not by common law liable, nor does he impliedly contract to keep the bridge in repair for the convenience of the grantee. On this principle, neither party, in the present case, is subject to any liability if, by reason of natural decay or other circumstances, his half of the wall falls down or otherwise passes into a condition that the easement thereover becomes impossible or difficult of exercise.
Which page are you on?
Electronic 1453, report 637, my lord.
Thank you.
I'm sorry, I originally gave you the next page by mistake.
It's the bottom paragraph on that.
Bottom paragraph on that, and it was referred to yesterday as the case of the bridge. It's actually a famous example, much quoted since. So if one goes back to these sort of examples of what a timeshare purchaser could possibly have contemplated when he took the benefit of this grant, one might say that the person taking a property complete with a right-of-way over a bridge probably wouldn't immediately say, I better start saving up for a new bridge. But if he did go and see an extremely perspicacious solicitor, he might be told that actually, if it were ever to fall down, unless you get a binding covenant in your favour for its rebuilding, which will be difficult if you want a freehold, not a leasehold, one day you might have to rebuild the bridge. So the short point is this: ancillary rights are limited to what is reasonably necessary for the exercise and enjoyment of the primary right or easement, and so ex hypothesi they are extremely unlikely to be excessive in their nature. Therefore, as I have already submitted for the purposes of the previous heading, mere passivity, the appellant's references to excavators, teams of groundsmen, teams of greenkeepers, etc., exaggerate the extent to which these ancillary rights could ever be exercised. As I told you yesterday, I'm not going to attempt to deal orally with ground 4 of appeal because my friend didn't deal with it orally, and we therefore simply rely on our written submissions, which are page 268 to 269, paragraphs 75 to 77. That brings me to the first head of the cross appeal, the swimming pool. Now, at page 275, in paragraph 95, we identify three possible meanings of the word substitution, in search at least of clarity. Not to be confused with paragraph 97, which starts at the foot of the same page, which at the top of 276 sets out the three ways in which we put the case. Now, the first of those, the basement rights case, the written submissions start at paragraph 98, lower down the page. This is simply a matter of construction of the grant. The basement rights case doesn't involve any questions of substitution. Although the swimming pool is perhaps now the most eye-catching of the facilities which are now in the basement or ground floor of the mansion house, ultimately this argument is about all of what are also called the indoor spaces, subject to the second head of cross appeal, so it applies to all the common parts and the ground floor and the basement. Now, we have a primary case and a secondary case as to this. Our primary case is to be found at paragraphs 98 to 101, pages 276 to 277. And we make this complaint about the judgment of the Court of Appeal. If you would turn to paragraph 373 for paragraph 40 of the Court of Appeal's judgment, they start paragraph 40 by saying that it was necessary for the judge to construe the actual words that the parties had used, but by the end of the paragraph, they themselves have written in some extra words, sporting or recreational facilities, into the wording of the grant, which for these purposes you may find most conveniently laid out on page 266. You remember the various limbs of it there spelt out. To the Court of Appeal, read in the words sporting or recreational facilities into the grant of ground and basement floor when they're not there, and they then refer back to that again. I'll just give you the reference in paragraph 80 at page 381. We say, by doing that, they mischaracterised the grant. This is simply a right to use an area of land, not a specific facility. And if you haven't already got it open, would you be kind enough to open, it's 267, the facing page perhaps, so to assist you in following the submission that I would now make. Suppose that a first-time occupier of a unit at Regency Villas doesn't bother to read through all their paperwork or leaves it behind at home in their excitement about going on holiday, and goes off to the main clubhouse reception on the ground floor of the mansion house and says to the receptionist, "I'm in Regency Villas, I'm here on holiday, what can I do?" And the receptionist answers, and the text is there in paragraph 73, well, you can use the swimming pool, you can use the golf course, you can use the squash courts or the tennis courts, you can use the ground and the basement floors here, you can use the gardens, or you can use any of the other sporting or recreational facilities that you find. Any reasonable person in those circumstances would understand what has been said to them. They wouldn't immediately head off for the private office behind the reception desk on the basis that they've been told that you can use the ground and the basement floors. They would understand perfectly simply that they can use the common parts of the ground floor and the basement floor. Nor would they think that they could go and demand a free meal at the restaurant. In my respectful submission, if you accept the submission I have just made to you about that oral exchange, the answer should be no different about the written grant which was made in this case. That is our primary submission. Our alternative submission, starting at paragraphs 102 through to 107, that's electronic pages 277 to 279, is based on taking it on the chin that the Court of Appeal might be correct to read in those extra words into the grant. If that is so, we nevertheless submit in those paragraphs that they were wrong to take a different approach to the indoor facilities to those which were located outside. There is no objection to there being a right to perambulate inside a building any more than the now undoubted right to perambulate in a pleasure garden. That's on page 278, our submission in paragraph 104. And here we are in the happy position of having a decision of no less than the High Court of Australia in our favour, where that court unanimously held in Arndale and Kilkenny, the reference to which is tab 99 or electronic page 2078, as you refer, a right to perambulate in a large shopping mall was upheld. It's not a judgment that's difficult to follow, so I won't take time to show you passages in it. We develop our alternative case later at paragraphs 234 to 240. The electronic pages are 333 to 337. And in particular, we take at paragraphs 234 to 235 the facts of another Canadian case. And we emphasise that because the land registration statute in British Columbia plainly contains different provisions and presumptions that aren't there in the English Act. So I emphasise we've simply taken the facts of that case to illustrate what we say is the obvious illogicality of taking a different approach to recreational sporting facilities indoors as opposed to outdoors. And we say, if you would turn please to page 382, that if one wants to identify a key sentence, which we say is wrong in the Court of Appeal's judgment on this, it would be the third sentence of paragraph 80 at the top of page 382, one line down. Moreover, what we have said about the modern approach to taking physical exercise is not really applicable to recreational indoor games such as snooker or watching television. We deal with this at paragraphs 335, pages 335 to 336, submitting at 236A that, for example, playing snooker or billiards is plainly sporting activity, and that there is no basis, we say at paragraph 237, for the sort of value judgment that downgrades the playing of snooker or billiards in favour of those who stand on a running machine or run around a squash court.
It's a bit like the Victorian eulogy of manly sports as opposed to others.
Well, quite. Well, indeed, in memory, sadly, of Judge Pearl, one might ask what sporting or recreational activities mean for someone in a wheelchair. So far as the use of chattels is concerned, 238 to 240, I gave you examples yesterday of a number of cases which involve the dominant owner taking their own chattels to exercise an easement. Clearly, if they don't, and this is wholly hypothetical, there was no evidence of this at all at trial or any suggestion of it. If you don't take your own golf clubs and you turn up to play golf and you ask to borrow around a set of clubs to do it with, of course, they're entitled to charge you for them, of course. So those are submissions on the first head for the swimming pool, the basement rights case. We'll take the second head, which we call the repurposing case, and this is not so very elegant English, I know, and I apologise for that. At page 280, paragraphs 110 to 111. Which, apart from a slip on our part, which I will come to momentarily, is a very short and simple point of obstruction. And it has occurred to us, really, as a refinement of the basement rights case. We have not argued this separately in either of the courts below, and I don't pretend otherwise. So it works on this basis. First, we have a grant in respect of the ground and basement floors. Secondly, we assume against our primary case that the Court of Appeal were right to construe that grant as limited to the sporting and recreational facilities there located. And thirdly, it's the basis of this argument, that the swimming pool is occupying land previously occupied by a different sporting or recreational facility. And of course, you will recall my learned friend drawing to your attention yesterday that is inconsistent with the statement of facts and issues. And it is inconsistent with the statement of facts and issues. That is simply because we did not pick up on the significance of the point, indeed hadn't formulated this refinement of the argument at the time that was agreed. So I can lay before you very simply what the position is on the material available, and I've told my friend what's coming on this, and identify the problem, and it's a matter for the court whether it feels able to accept the argument or not. If we start perhaps with the table of facilities again at page 469, you'll remember what was said about this in paragraph 14 of the statement of facts and issues. On the third page of that table, in the middle column, indoor swimming pool constructed in 2006-2008 following Judge Penning's order in area previously occupied by gymnasium with smaller reconfigured layout, gym and sauna attached, together known as the leisure centre. Mr. Robson's witness statement, paragraph 4.9, and cross-examination. You have Mr. Robson's witness statement, paragraph 4.9, at page 773. It should be 775, I'm sorry, forgive me. And it's quite clear. In 2006, the indoor swimming pool was constructed in the basement floor where the former gymnasium was located. As part of the 2006 works, the basement floor was reconfigured to accommodate the new gymnasium. A new treatment room was added. That is the appellant's own witness statement. There was no question from either the judge or my own friend Mr. Latimer at trial suggesting that this table put before the judge as a fair summary of the evidence was in any way wrong. And I have seen for the first time since the trial took place Miss Longstaff's note taken during the evidence of Mr. Robson. I've shown it, the whole of it, unedited to my learned friend yesterday, and having seen it, I have no professional difficulty in putting that table before the court, as I did before the trial judge, as an accurate table. I submit, having conducted the trial myself, that obviously nobody has a perfect memory. As I told my friend yesterday, I would submit that, so far as I'm aware, there was no evidence, documentary, witness statement, or oral, before the court, which contradicted that and gave the different version to be found in paragraph 14F of the Statement of Facts and Issues. If my friend were to point, as I told him yesterday, to any contrary evidence that exists, I would have to take a different view on pursuing this point. In those circumstances, I submit that it would not serve the interests of justice to hold us to what we say is a slip in the Statement of Facts and Issues, there being absolutely no evidence to support it, and all material being to the contrary. Whether the court is prepared to indulge us in that respect or not is a matter for the court, but that is the factual position, fair and square. Thirdly and finally, with regards to the swimming pool, we have what we call the repositioning claim. Hopefully that name at least encapsulates what's coming. And given the time constraints, I will simply give you a summary of how the issues play out and invite you to rely on our written submissions, which are fairly full on this. They are to be found on electronic pages 280 to 291, paragraphs 112 to 1144. And the point of the summary is how this fits in, and it picks up on questions my Lord Sumption asked my learned friend yesterday. Our primary argument, you will remember, is that the grant of the swimming pool is a grant to use the swimming pool for the time being, if I may put it there. The swimming pool that is there on the site for the time being. And we only need this repositioning case if we are wrong about that. If we are wrong about that, then we say that as a result of the first and second appellants or their predecessors filling in outdoor swimming pool, and clearly wrongfully in 2000, then either A, our right transfers to the new one because the new one was built in direct substitution for the old one. That case is developed in the written submissions. Or B, so long as the outdoor pool remains closed, we have the self-help remedy of using the nearest available alternative, as in the right-of-way cases, most famously at Selby and Nettlefold. So that is how we construct it, but that's all, in a sense, myself to answer Lord Sumption's question to my friend yesterday. We only need the secondary bit if we fail on our primary argument that the swimming pool means the swimming pool for the time being.
And do you make that construction your primary case in relation to everything in the grant, namely it's whatever for recreational sporting facilities are to be found within the reserved estate at whatever time somebody wants to use them?
No, we don't go that far, my lord. And that's the one difference between us and Judge Pearl. And Judge Pearl went a bit further than we actually asked him to do in our skeleton argument. We say, obviously the grant applies to facilities that are there to start with. Suppose the tennis court is ploughed up and turned into a second croquet lawn, and a new tennis court is built elsewhere on the transferor's adjoining land, to use the last words of the grant. That, we say, our grant would apply to the new tennis court just as it applied to the old, provided it's on the transferor's adjoining land.
Yes.
We don't say, as the Court of Appeal said, it can only be a tennis court on exactly the same bit of land.
Well, I don't think that's inconsistent with the point that was put to you by Lord Briggs, is it?
Well,
I'm sorry, my lord?
I mean, I don't think that that's inconsistent.
No, it's not inconsistent. No, it's not. But the qualification to what Lord Briggs put to me is, what we say, I'll take the example we used in the Court of Appeal. If an entirely new facility, say a snow dome, an indoor skiing slope, is built behind the Diamond Lodges, where there's lots of land, that is not in any sense a facility that we are granted. Originally, it isn't a substitute for one. It isn't the snow dome for the time being, because the snow dome wasn't on the list. And we do not say that just because that was built somewhere on the transferor's adjoining land, the grant automatically extends to it.
Is it not an other sporting facility?
Well, then that question, my lord, we are perhaps we're being too hard on ourselves, but we are...
Well, that's a neutral question. I'm not trying to encourage you in any particular direction. I'm just reading the grant.
As we have submitted in writing about those words, my lord, we say... Is it 84 and 85? Can you check? What we say those words apply to, two things. Firstly, other facilities that weren't mentioned in the list in the first place, so the riding stables...
But were there.
But they were there in 1981. Or secondly, it would pick up the concept of substitution. I'll be entirely open with the court as to my reasoning for not entirely backing Judge Pearl and just saying yes to Lord Briggs. I am troubled by what the position would be in respect of the law of perpetuity if I was to go for that. And one gets into very recherche arguments that may or may not be dependent on exactly where the scope of the servient tenement is. This being a grant made after the 1964 Act but before the 2009 Act, the perpetuity period would cover us for the first 21 years after 1981 but not after that. No relevant new facilities were built in the first 21 years. Therefore, the anxiety would be back in the position of, say, Mr. Justice Cross's case, done and whatever it is about a new easement to be provided at some indefinite time in the future, which he held to be ineffective for perpetuity, or would be able to say, well, it's not perpetuity because the right granted was over the whole estate, and therefore in some way we would be able to outflank the perpetuity period and going with what Judge Pearl said. We didn't expect Judge Pearl to give us that little bit more than we had asked for, and therefore we didn't address him about perpetuity at all. We did draw that to the Court of Appeal's attention. I got fairly short shrift from the Chancellor when I did so, but in the end we ended up with an agreed written note to the court about what the law of perpetuity is. It's for that reason that I have not chosen to go for any entirely new facility, not covered by the grant, not being direct substitution, merely because it's somewhere in that very big area of land that you see on the large plan. If I'm wrong on that, and the grant is effective in respect of entirely new facility on entirely new part, my clients will be delighted if you so find, and will no doubt be kind to me about not having argued it for them. That is my case, and that is why it's my case.
Does it depend on whether you can't treat this as a single easement to have use of a quite compendiously described sports and recreational complex, which one would think is bound to change in its detail from time to time, or a lot of little easements which have to be salami sliced to understand the grant?
That is one of the issues that would arise if one really got into perpetuity analysis.
I mean, if it was the former, would you be in a perpetuity problem?
No. But
You'd just be an easement over a slightly fluctuating beast.
Yes, but it does instinctively feel, contrary to the perpetuity principle, that something that comes in not previously mentioned on a piece of land not previously affected that pops up 40 years later. And Mr. Brown, very helpfully, if I can give you the reference, it's page 710, in what we put to Judge Pearl in writing at paragraph 102 at first instance was, as for the phrase, any other sporting or recreational facilities on the transfer or its adjoining estate, it is submitted that by this phrase, the transfer grants rights over the facilities as such were present at the time of the grant, or such facilities as are provided in direct substitution therefore. So we may have been consistently wrong, but at least we've been consistent since the trial at first instance.
Sorry, just to complete that, which is the paragraph of Judge Pearl which goes further than you were asking?
Oh, when Judge Pearl goes further than us, that is, I think it's 44, my lord, on 398.
Yes.
It's not very must, in my judgment, include facilities that were not there or planned in 1981 or which may have been significantly improved since then. To construe the rights as limited to the actual facilities on site or planned is unrealistic, might inhibit changes, etc. We adopt the bit about unrealistic and that changes were an obvious possibility, but we don't push it as far as he did. We said that should cover us in respect of direct substitutes and so forth. And as I say, if I've been too cautious on this, I'm more than happy to be corrected. My ladies, some more good news now. Cross-appeal...
Can you just give me the page number of your note on perpetuity for the Court of Appeal, just to save me an awful lot of homework?
Neither side has put that in, but we can provide a copy. It was an agreed note before.
It might help.
Okay, I'll arrange for that. We'll have that in PDF form. You've got that on your list, Katie. Thank you. Cross-appeal head 2, the indoor spaces, that's dealt with on pages 333 to 337, paragraphs 233 to 241. I've already argued that in the course of dealing with the swimming pool and don't need to repeat those arguments. It just gets a separate mention, treated as a second head, because there are things other than the swimming pool in the ground floor basement. Which brings me to the quantum merit claim. We deal with that starting at the electronic page 338 and the paragraph 242 and following. I don't propose to develop the legal arguments. I shall attempt to give you a very clear structure as to what we say and why. The appellant's claim for a quantum merit is for payment in relation to facilities over which we fail to establish an easement for free use. If we establish an easement for free use, there's no question of quantum merit. So on Judge Pearl's judgment, as we had an easement to use everything, the question of a quantum merit simply didn't arise. The Court of Appeal, if I may put it this way, took away from us the easement over the ground floor and the basement of the mansion house, so in particular, but not only, took away the swimming pool. So the Court of Appeal's ultimate order for an assessment of a figure on a quantum merit necessarily relates to that only. And if you'd be kind enough to turn to page 360 for reason D in the Court of Appeal's order, it's quite clear that that is the case. They say in the third line, the consequence of the Court of Appeal's decision is that the defendants are entitled to an assessment of the sums due in respect to the services provided that were not simply the exercise of the easements now determined to exist. This will include the use of the indoor swimming pool from the 1st of January 2012. In principle, it would apply to snooker or other things on those floors. In practice, the charge there was levied anyway, and so forth. There are three features to the order of the Court of Appeal which I am going to draw to your attention because I say they're important and because I say once one has those firmly in mind, the ambit of the quantum merit thing becomes quite clear. The first of them is to be found on page 357, and it's paragraph 2 capital A. Very strictly, it's paragraph 1 brackets 2A, where the Court of Appeal say that the term services is not to include the costs of general maintenance or upkeep of the golf course or other facilities which are the subject of the same easement. Our submission based on that is on page 341 at paragraphs 248 to 249, but the quickest way of understanding this is to go to page 752, please, because the particulars of the claim pursued in this regard were never put in the pleading. We're not taking a pleading point about that. It took the form of this paragraph from the skeleton argument, paragraph 72, and it cross-refers to paragraphs in the witness statement of Ms. Garrow. I'm not going to take time to turn to those, but if it helps you to note the numbers, the paragraphs 17.1 to 17.11 may be found on electronic pages 765 to 766. Paragraphs 8.1 to 18.13 may be found on pages 766 to 767, and paragraphs 23 to 24 may be found on page 770 to 771. Now, it's the third box here charge apportioned for 2015, £211,000. As we submit it at paragraph 247 on page 340, this is not contradicted in the new paragraphs in reply in any way, and can be checked against the underlying documents if you wish. Now, I've given you the references. So we're at the bottom of page 340, comprised an apportioned share of operating costs, of depreciation, of annual recovery of 10% of the capital expenditure on buying the place in the first place, and a 15% profit margin. We submit that it is quite clear from paragraph 2A in the order that none of that is recoverable, so the third head fails in limine. Secondly, going back to the order, please, at page 357, for insertions into paragraphs 1 and 2. So the format of the order, as you've picked up, this is rehearsing Judge Pearl's order with the Court of Appeal's tweaks, if I may put it that way, underlined. So you see underlined in the middle of 1 and in the middle of 2 on page 357 these words, or for services, or for the use of any of the defendant's chattels. Now, these paragraphs are declaring rights for the future. Contrast over the page at 3. At 358, at the foot of the page, subparagraph 8 is dealing with the monetary award in respect of the past. There be judgment on the defendant's counterclaim for quantum merit in respect to services provided from 1st January 2012 to the date hereof, and then these key words, but not paid for. Now, contrast with that at page 429, please, in the what's agreed on both sides to be the only relevant 3 lines of the counterclaim. This is page 429, paragraph 47.2. The claim was for quantum merit, etc., which for services, which RVOC members have received but not paid for, or not paid for in full. And the Court of Appeal gave them the first limb of that, but not the second limb. So if for things which no payment was made, they got their quantum merit order, bottom of 358, top of 359, but, and this was the paragraph number they'd been referred to in the written submissions, of course, they did not get an award in respect of things not paid for in full, or as the word that's been adopted in the written argument, where a concessionary charge was made. So, if one wants to know what the effect of that is, one goes back to page 752 for the table, and that knocks out the first of the 3 boxes, because green fees were always charged through 2012. All that happened was that they were increased in February and increased again in July. So that leaves the middle box, the claim for swimming, for which no charge was made between January and a date late in July 2012. Now, in that respect, that claim we would accept is a claim which is arguable on the facts. It hasn't been pleaded out in any detail by either side. No judicial officer at any level has heard evidence or formed any findings about it. And in principle, and I say in principle, I mean the parties managed to come to a perfectly realistic settlement of a much larger financial claim without going back to court about it. Just in principle, there is an arguable claim there for £2,100. So, if you would go, please, to page 237 for the appellant's written case, we can now see what is and is not in issue. So this is paragraph 1571, 2 claims intimated.
Can we have a page number?
Sorry, 237, I'm so sorry.
I may have missed it.
Forgive me, 237 at the top. So the Supreme Court allows the appeal. So there are some rights that Judge Pearl gave us, the Court of Appeal's given us, they're taken away. The respondents will have had one, if I can put the number in, concessionary use of the facilities, and that must refer to golf, because golf is the only one that was charged for, swimming wasn't charged for at all. And two, free use of all the facilities since the trial judge gave judgment. The first one fails for the reason I've said. It's outside the Court of Appeal's order, and the appellants have not appealed that. The second one is entirely new. The first we knew of this being relied on was 2 or 3 weeks ago when we got the new version of the appellant's written case with the, this is one of the paragraphs added into it. Now, if you could either turn up 387 if you wish, or just take it from me orally, one of the things we got from Judge Pearl, paragraph 4 of his order on page 387, was an injunction restraining the defendants from charging us for the facilities. Now, we accept, of course, that if an appeal court takes away from us a facility in respect of which Judge Pearl gave us that injunction, and we weren't entitled to that injunction, then yes, of course they can then claim a reasonable charge for the fees for the period over which they were wrongly enjoined. It's never been raised before, but we wouldn't dispute that. We simply note from the wording of their paragraph there that insofar as the swimming pool is concerned, that stops in April 2017 because they started charging again. So that's paragraph 157 sub 1. Paragraph 157 sub 2, again there are two limbs. So if you dismiss both appeal and cross-appeal, so we stay with a position where we've got rights, including, for example, the golf course, but not got rights in respect to the swimming pool. Firstly, they say there's the much more modest claim for £2,100, but we agree they have an arguable claim for that. And secondly, there might also be scope for a claim for a larger sum, and this is the concessionary bit. And we say, no, there's no scope for that at all, because the Court of Appeal have only made an award in respect of things for which no payment was made, and there is no scope for that. At paragraph 159, we're criticised for two things, for setting the parameters of the seeking to set the parameters of the quantum merit assessment, and secondly, seeking to preempt the assessment. We plead guilty to the first and make no apology for it. It's entirely appropriate if there be an order for a quantum merit that the parameters be set. It's not for the matter to be entirely at large. And indeed, if one looks at the reference in paragraph 151 of this to the expert report, £70,000 to £80,000 a year for the leisure club, numerous references to concessionary fees, it is necessary for the parameters to be set. Are we seeking to preempt the assessment? No, we're not. I finish by inviting you to make these 4 decisions of principle. 1, that heads 1 and 3 set out on page 752 fail in limine for the reasons I have given. Second, in the event that this court does not find in our favour with regard to the swimming pool, then the arguable claim for £2,100 for free swimming, January to July 2012, should be remitted. It can't now be Judge Pearl, of course, probably a district judge given the amount, for a factual inquiry on the issues in paragraph 264A to B of our skeleton argument, and an assessment insofar as liability is found. There's every reason to think the parties will take a realistic view. That's just a position in principle. Thirdly, I invite you to decide there is no liability for top-up charges where an allegedly concessionary fee has already been made. Court of Appeal Order 1, brackets 8. And fourthly, or finally, that insofar as the newly raised matter, matters in respect of which the other side were wrongly enjoined under paragraph 4 of Judge Pearl's order, and whether there are any, of course, depends on this court's determination, but if there are any, yes, certainly an order for an assessment over the relevant period would be appropriate. Those are the 4 decisions of principle that I respectfully say this court should make. Therefore, just a couple of administrative matters then. Firstly, you have been provided tonight, as promised, in PDF form, with the case note on Ellenborough Park from the Cambridge Law Journal and the lease, or the 35-year lease of the upper floors of the Mansion House. If the court would like it, I inquired of the staff and they told me basically to ask you, my lady. We've got 8 hard copies here if you want them. So,
Well, why not let us have the hard?
then they'll be
Yes,
passed on.
thank you.
Secondly,
Well, Mr. Randall, you have already exceeded your time
well,
by
the
15
30 seconds is, with your permission, there are, I think it's 7 numeric corrections to numbers quoted in our footnotes, most are attributable to the paragraph numbers in the appellant's written case changing when they put the reply. If we may submit a typed list of corrections before the end of the week, I'd be grateful. Thank you for the extra 2 minutes to enable.
Of course you may.
Thank
But you have gone 15 minutes over your time, because you started 15 minutes early.
Well,
So it may mean you've got no time to reply on quantum merit.
we'll see.
Depending,
Well,
depending how Mr. Morshead goes.
thank you, Mike.
Mr. Brown?
Nothing further, my lady. Sorry, I stood too early. I have back the lecture.
Oh, of course, yours. Sorry. Just one.
Just one's fine.
Thank you.
My lady, the 1981 transfer is now acknowledged to be the product of conveyancing error. It didn't do what it was meant to do. The question is whether the different thing it did do enables the respondents to hold the appellants to commercial ransom forever, because we're dealing with freehold rights. The only principle relied on to secure this result is that the court should lean in favour of an interpretation which validates the instrument. But this rule only applies in the most marginal of cases, as that extract from Lewison, which we mentioned in our case, makes clear. It's in Volume 4, tab 69, memory stick 1782 and 1784. In the present case, the intended scheme failed because of conveyancing error, the draftsman of the scheme not having understood adequately what he was doing. That is beyond what can be cured by a process of interpretation. You cannot cure a scheme which failed this significantly by that process. Further, my lady, in what sense does the respondent's interpretation validate the instrument? I suggest you are being asked to elevate form over substance. If the respondents are correct in their interpretation, then what was created was, in form, an easement. The trouble is, it lacked all the substantive qualities of easements which are used to justify recognising them as property interests. The rights created are of no utility to the dominant owners in relation to their land. What they are a blight on the freeholder's facilities, precluding the freeholder from making productive use of his land without also allowing the respondents to use his facilities. My lady, that is precisely the kind of interest which the Law Commission says should not be allowed to exist in perpetuity as a matter of legal policy, and one can readily see why. My lady, I suggest one cannot ignore the practical implications of the respondent's interpretation. We're dealing with freehold interests, so the implications might be perpetual, and they should be considered on that basis. One implication is that the villas and the rest of the estate, which is owned by my client, could become completely struck with sterility, not just for a few years, but forever. If he thinks the numbers don't add up, my client can simply mothball the whole facility, recreational facilities now available to the community are lost, jobs are lost, the productive use of this land is lost, the respondents will have no reason to visit their villas while each side waits for the other to blink first. Potentially forever. Now, this might not happen today, but it might happen after leases of the other parts of the property come to an end, or at some other time. And as we're looking at a time frame of perpetuity, we need to bear this in mind. It can't be dismissed as an idle, fanciful possibility. It might not happen now or in 10 or 20 years, but what about 30 or 40 or 200 or 300 years? It is legitimate to invoke those time spans because we are dealing with rights which are purportedly effective in perpetuity. The respondents say they are entitled, if they want to provide and operate their own facilities, their own golf course, their own swimming pool and so on. But they haven't suggested to you that they could ever do those things. Operating the facilities is only viable because they are offered by my client as part of a wider commercial undertaking offered to the fee-paying general public, which is something the respondents cannot do themselves and haven't suggested they could. So even if they did muster the necessary funds and did reinstate lapsed facilities or start to run the golf course and so on, they would then be unable to stop my client from coming back on and exploiting that expenditure and monetising it. The whole situation is frankly an absurd muddle. You couldn't ask for a better example of why you should resist this siren call of taking a relaxed view of what rights can bind land in perpetuity, or of why you should not strain to interpret the transfer as giving rise to such risks. My lady, it's not even correct to say, as my learned friend did, that the parties got along perfectly well for 30 years. What the papers show between pages 548 and 569, there are only 9 letters, from 1992 onwards, is a protracted quarrel. What's happened is that the respondents and their predecessors have bought their way out of having to test their rights for many years. There has in truth been a state of protracted, almost constant warfare, suppressed by the fear of what might emerge from litigation. And this has gone on since at least 1992 and came to a head in about 2012. And my lady, for another thing, again, we need to be careful to adopt the correct perspective from the point of view of time. What the papers show is an improvised, ad hoc, non-contractual arrangement, not the exercise of this supposed easement at all, but the use of facilities pursuant to some completely different, improvised arrangement. And that is what has kept litigation at bay for 30 years, not the use of the easement, but the uncertainty of the situation present on the ground. Now, in the context of freehold rights, what is most striking about this is not that people got on perfectly well for 30 years, as Mr. Randall puts it, but that those arrangements collapsed irretrievably within as short a period as 30 or so years after the grant itself, a mere drop in the ocean in the eyes of perpetuity. The resulting situation is not a function of anything recognisable as, or that ought to be recognised as, perpetual property rights. It is a complete muddle which vindicates the policy of the law to exercise caution about recognising rights as perpetual, a policy considered and upheld as recently as 2011 by the Law Commission. And the outcome that these respondents seek is a paradigm example of one which ought not to receive the blessing of this court as a matter of property law, unless compelled to do so by some clear, unanswerable rule of law, precisely because it manifests so many of the problems associated with being too ready to recognise perpetual rights. This case demonstrates very clearly the need to maintain legal discipline and clarity about what rights are and are not admitted to the rank of property interests, especially in this case, where the issues are now available for the first time for comprehensive consideration and review at the level of your ladyship's court. There's a need to hold the line. Now, I suggest that those considerations indicate powerfully two things. First, you should not strain to interpret the transfer in the way suggested by the respondents, quite the reverse. You should not adopt the respondents' interpretation unless driven to do so by the clearest possible language. I suggest if you have to choose between applying a maxim of interpretation which favours leaning in favour of validating instruments but attracts consequences which are precisely repugnant to fundamental principles of property law, on the one hand, and adopting an interpretation which is available on the language of the grant and which avoids those consequences, it should be clear which one wins. If the respondents are right, then why not also will we find that one can have an easement of a sauna? Because after all, if the owner doesn't turn the heating on, I can take in my own oven. Or a restaurant, because after all, if the cook won't cook my meal, I can take in my own food and cook it myself. Or a bar, because if the barman doesn't serve me, I can take in my own alcohol. Or London Zoo, or Lord's Cricket Ground. Secondly, I suggest you should not sanction a test of accommodation which is indifferent to the risk of situations such as this one arising in future. Rather, you should sanction a test which respects the status of property rights as interests in land, including, of course, use of land, but linked in some meaningful way to an enhancement brought to the occupier of land in his or her actual use of the dominant land. It is a conceptually clear target which should be capable of clear expression. Where the right in question is in substance an independent right to enjoy someone else's land without involving any actual use of the dominant land, some other control is manifestly needed to provide the necessary connection. And none has been offered in any authority shown to you, apart from the test adopted by the Master of the Rolls in Ellenborough Park. Diluting that test in the way suggested by these respondents increases rather than minimises the potential for absurd consequences such as we see in this case. My lady, the respondents say my approach is too narrow. But on their approach, a hotel or a restaurant might acquire an easement over a swimming pool, even if the swimming pool is a commercial undertaking shared with paying members of the public, admitted for a fee by the owner. And that's because, they say, this enhances what they call a normal use of the dominant tenement. But by the same reasoning, the owner of a factory could not have the self-same easement, because recreation is not a normal use of a factory. This is arbitrary. It's unrelated in any identifiable way to the purpose of the test as a way of filtering out interests which are not sufficiently related to land use. Not particular land uses, but use of land. Merely because recreation is not a normal use of a factory doesn't make the privilege of swimming any less useful or attractive, whether viewed as an asset of the factory itself or as an advantage to the people who occupy the factory. What's more, the test proposed by the respondents is essentially discretionary. because it's based on a value judgment about what is normal. Indeed, the respondents acknowledge that they see the test ultimately as being one of fact. That's not just not helpful. Further, this idea of normality is circular, as discussed in argument. So we say that the respondent's test doesn't relate to whether the use in question enhances land or the use of land in any way that's coherent or suitable for adoption as a legal test. In fact, the test becomes so divorced from the land as to become a bare technicality. It just becomes an unprincipled trap for the unwary. And it's hard to see how it would exclude the free use examples or others like them. It doesn't avoid the consequences identified by the Law Commission and which we've mentioned. And it raises the question, my lady, why preserve the test at all? Why not simply do away with it and abolish the rule against easements in gross? We say it is the privacy of the use of a shared facility situated sufficiently near the dominant land, available for use by a limited number of dominant owners, which the Master of the Rolls recognised as enhancing the utility of the dominant tenement. On this view, the owner of the factory can take an easement over a swimming pool, no less than the owner of a hotel or timeshare resort, provided that the right is, in a nutshell, to cover all those points, a private one, in the sense described in Ellenborough Park. This gives effect to the core purpose of the accommodation test. It correctly focuses on an objectively discernible characteristic which shows that a right affects land or the use of land without any need for value judgments about what particular use is being made or is proposed, either of the dominant land or the servient land. And in passing, I note it is in keeping with Mr. Justice Warren's disinclination to allow value judgment to influence this area of the law in Polo Woods. So I don't accept that my test is any narrower than the respondents'. It's different, and potentially it operates more widely. It so happens that it would exclude the respondents' rights, but that is because of a conveyancing error. Given the error, it is unsurprising to find they don't have the rights for which they contend. Indeed, it would be an uncovenanted windfall if they have the rights they ask you to recognise. It merely enables them to hold my client to commercial ransom forever. Our approach follows precisely the reasoning of the Master of the Rolls in Ellenborough Park, which is acknowledged to be the leading case. It respects the principle that we should identify the characteristics of a right which ought to distinguish it from a mere personal right, and so attract the privileges of a right in rem. My lady, the problem with recreation rights is that the use of the right is complete in and of itself away from the dominant land, without any trace or echo of it being felt on the dominant land or in the use of the dominant land itself. It's that feature which made the Master of the Rolls grapple in such detail with the matter in Ellenborough Park. The usual way of satisfying the accommodation test cannot apply in a case such as this. The Master of the Rolls explained how, in that situation, you can plug the gap. The Scottish textbooks show that the difficulty is recognised in Scotland and that there is uncertainty about the situation. Incidentally, it is unfair to imply that in quoting Rankin, we're relying on an out-of-date textbook. It was cited with approval, albeit not in relation to golf, as recently as 2008 in a case called Romano. That's in Volume 5, tab 95. I would refer you to page 2065, paragraph 24. Gordon's textbook, which you were shown, recognises there is a lack of clarity in this area and does not suggest that Scottish law has already found an answer. And in fact, his suggested approach, it's not more than a suggestion, is one I would respectfully criticise for reasons I have explained. It doesn't deal with the problem faced by a factory owner who wants a swimming pool for its employees. Now, Mr. Randall showed you a number of cases as authority for the proposition that there's no cast iron rule against an easement of recreation. If he gained momentum with that line of argument, it is because he was pushing at an open door. We have never suggested otherwise. English law does not have a closed list of easements. In this it differs from Roman and to some extent Scottish law. But all this means is that there is no kind of right which an English court will refuse to examine as a potential easement. That is the only point made in the extracts from the old edition of Gale you were shown, in volume 4 at tab 70. It means that the court in England is willing to test any right against the requirements of easements, including accommodation. But, my lady, a corollary of this is that one must be especially careful to identify and apply correct legal principle. Where you have a principles-based system rather than a list-based system, you can't proceed by analogy directly from rights which have already been recognised as easements without also examining the reasons why earlier rights were regarded as meeting the test of accommodating the dominant tenement and so on. And on a correct approach, I suggest one can only proceed by analogy with an acknowledged easement if the same reasons apply as those which led the first right to be recognised in the first place. To take an example of this, Mr. Randall cited that case of Riley and Pentilla in volume 5. I'd like to turn this up, please, because despite me asking him to, he skipped over the passage that's important.
Page?
2146 is where the case starts. If you kindly go to internal page 559, just to locate where we are. This is, memory stick 2158. The passage that begins, "For gracious living it has been found." The lines he skipped out of the paragraph on the next page are these. Although each block here, according to modern standards...
Where are you reading from? Line?
2159, line 4. Although each block here, according to modern standards, would be regarded as a large allotment, nevertheless, it would undoubtedly add to the enjoyment and occupation of each block to have the added liberty of using the contiguous, large, private area closed to the public for the purpose of recreation, garden, or a park. Riley and Pentilla is supportable precisely because it recognises the control which must be applied in this special kind of situation. It recognises it and it applies it. We don't need to be hung up on whether the application to the facts was correct. That is the test which was adopted. And indeed, when we look at them with enough care, we find the same is true of at least two of his other examples, which he hurriedly took you to. The first is Ducat, which I showed you. And you'll remember that that was a case, this is in volume 6 at tab 116. This was a case in which the private right to use the foreshore had running across it some private rights of way, some public rights of way. But that no more detracts from privacy than a footpath at the bottom of my garden, or a bridle path at the bottom of my garden. The garden is still private and mine, even though a lesser limited right exists over it. There's that case of City, I think it's City Developments. I need to invite you to open that up again, please. This is in volume 5. tab 101. Can I ask you to go to page 2096, paragraph 29? The judge said, I adopt and apply the principle expressed by Justice Gillard in Riley and Pentilla. And the extract she quotes includes the lines I have just read to you about the need for privacy. That's my shorthand for the concepts we're talking about. I hope that's understood. And we then see her conclusion at paragraph 38 on page 2097. I also agree with the submission made by Mr. Barr that the inference to be drawn is that the intentions of the grantor were to create a large recreational area available to the owners of the many sections of land surrounding Lake Bennett, focusing on the lake itself, but also on the surrounding foreshore. The whole former section 152 was subject to the grant of easement for recreational purposes in favour of many separate landowners. Now, one can question whether the judge applied correctly the principle she had identified to the facts, whether the facts supported an inference of dedication. But that's what she thought she was doing. And in the Court of Appeal, this was recognised. If you turn over to the next tab, or just look at memory stick page number 2106, 5 or 6 lines down, the Court of Appeal correctly characterised her reasoning in this way. Her Honour inferred that the intentions of the grantor were to create a large recreational area available to the owners of the sections of land surrounding Lake Bennett, the recreational area to comprise the lake itself and the surrounding foreshore. And that was the basis on which the case was decided. My lady, this is the first time that the issue of accommodation has been addressed at this judicial level. It's simply not helpful to be presented with an array of decisions without being shown what reasoning they adopt, so that you can reflect on what weight, if any, they should receive in shaping the law at this final appellate level. Yet you have not been shown any reasoning which shows that one can proceed by analogy with communal gardens in Ellenborough Park unless you also find facts analogous to the privacy factors in that case. And if there are cases where the need for what I have labelled privacy hasn't been applied, it might be that the point for some other reason was not in issue, or the matter wasn't argued, or was overlooked, or even that the decision is simply wrong. So you learn nothing from the existence of such cases without knowing what the reasons were. Blankstein is an example of the dangers of this scattergun approach. If you wouldn't mind going back to volume 5, page 2082, I think it's tab 100. This case was decided on the basis that the alleged easement had been enjoyed for a long time, but only by permission, rather than as of right. That's what the case ultimately decided. And when you look at the part of the reasoning which examines whether the right was capable of being an easement, all you find is at manuscript page 2087. Ellenborough Park is mentioned. It was held that the right to use a private pleasure ground was an easement known to the law. Case didn't deal with an easement by prescription. I conclude on this authority that the kind of rights claimed by the plaintiffs over the defendant's property for right-of-way and recreational purposes can be the subject matter of an easement. That's it. Well, how on earth is that going to advance your ladyship's consideration at this level about how the law should develop and be stated? And likewise with the Cambridge Law Journal we were shown. I mean, that case, for example, seems to have been written by a person who hadn't understood even that in the context of landlord and tenant, the dominant tenement can be regarded as the reversion and the servient tenement as the demised premises. I don't need to apologise, with respect, for being rude about that level of contribution. In short, we have seen no reasons explaining what the Master of the Rolls' justification for distinguishing the free use examples was unnecessary, or was only necessary when you're looking at gardens attached to houses, or that in other particular circumstances you can dispense with the considerations that he looked at, or if so, why? You've been shown no explanation of what might supply the necessary connection, as it's put, between the right granted over the servient land and the dominant land or some use of it as to amount to an enhancement if those factors are missing. And there is certainly no authority for the proposition that a right to share the use of a commercial undertaking open to the fee-paying public is any different from a right to visit a restaurant or a sauna or a gym or a zoo or a cricket ground. Now, a beguiling attempt has been made to create the impression that we are the ones swimming against a tide of authority. But we must remember that the ability of the respondents to rely on Ellenborough Park, in truth, depends on whether or not they can justify extending the Master of the Rolls' reasons to the present situation. And in this, they are the ones who are unsupported by any authority. They are hampered by the free use examples. They are unsupported by any principle they have identified beyond their normal use test, which, as we have seen, is unprincipled, circular, laden with value judgment, and completely unsuitable to be sanctioned, if I may say so, by this court as a legal test. And furthermore, the impression is misleading. First, it partly depends on the momentum gained by Mr. Randall from pushing hard at doors which are open anyway. I've mentioned one of them, that recreation rights are a no-go zone for easements and that the category of easements is not closed. But another one is the idea that my argument disregards any benefit arising from the use of land as distinct from benefits to the land itself. I don't accept that any reasonable person reading my case could genuinely consider that this formed part of our argument. I refer, for example, to paragraphs 41 to 42. Another one relates to the use of the dominant owner's chattels on the servient land. You don't need citation of authority to make that point. Anyone using a car on a right-of-way is using his own chattel on the servient land. None of that sheds any light on the question of accommodation. Secondly, it also partly depends on the momentum gained by cases cited for one thing, but when actually read, relate to another. I'll give you two examples. The first is Hayward and Mallalieu. This was cited as authority that a right to use a kitchen for brewing and so on was recognised as an easement, but it's no such thing. A claim for specific performance of a contract for sale of land failed because the vendor had failed to disclose a mere claim to such a right. The court did not say a single word about the validity of the claimed easement, let alone about the test within easements of accommodation. Wilcox and Richardson is another example. This was cited as authority that a right granted to a fish shop to share space for the preparation of fish was recognised as an easement. In fact, that could hardly be contentious, as the fish, once prepared, would be sold from the shop. It's a classic example of an easement benefiting a business carried on the dominant tenement and not merely from it. But in fact, my lady, the validity of the right as an easement was not an issue argued in the case. The issue was whether the right passed under the rule in Wealden and Burrows as a quasi-easement, which was of a continuous and parent nature, and reasonably necessary for the enjoyment of the land granted. There's nothing here about accommodation either. There was also that case, I think it's Grant, which was said to show that one can look on the whole of the estate as being the servient tenement. It says nothing of the sort. What it says is that a right is valid to go onto land and select the part of it which is going to be affected by the easement. There's nothing controversial about that. But once that, to take the simple example of a right-of-way, once the right-of-way has been selected, the easement is attached to that route and no other. It comes nowhere near supporting the idea that was put forward by my learned friend. And thirdly, this impression also partly depends on cases cited for the uncontentious proposition that lots of different easements have been recognised. Doughty, the airfield case, was offered as an example, but a right to use a field adjoining the dominant land as an airfield to go to and from the dominant land is indistinguishable from a right of way and raises no question of accommodation. None was argued. Platt and Crouch concerned rights of mooring and whether they passed under Section 62. The argument that they didn't pass had nothing to do with accommodation. I refer you to paragraph 26, if you're interested, in page numbers 1565. The argument was about whether Section 62 had been excluded either by the common intention of the parties or by ouster. Miller and Empser is about a right to use a lavatory. There was no argument about accommodation, and in any event, a right to use a lavatory has a similar relationship to an easement of sewage as a right of car parking has to a right of way, as we pointed out in our case, and which hasn't been challenged. What is missing from this torrent of authority is any reasoning or statement of principle that helps the respondents to explain why their rights should be recognised as easements despite the fact that they don't satisfy the Master of the Rolls' tests in Ellenborough Park. Now, my lady, overnight we provided to the court an extract from McGarry in response to a question of my Lord Carnwath. I don't know whether you've had an opportunity to review that, but it's available. It's consistent with our submissions in my respectful submission.
Thank you.
So far as concerns the case of Hill and Tupper, I've got just one short submission on that. Whether or not Hill and Tupper is rightly decided, the proposition of the Master of the Rolls in Ellenborough Park is what matters, and that proposition is correct in my respectful submission. So far as concerns Duncan and Loosh, which is referred to in Ellenborough Park, it's sufficient to refer to the quotations from Duncan and Loosh in Ellenborough Park itself to see this point. If I might ask you to look this up if you wouldn't mind. It's in volume 2 at tab 26.
Page.
I'm sorry, I've given you the wrong reference. It's volume 1, tab 5. And I'm now getting my bundles in a muddle. Page 878, my lord.
870?
878, my lord.
878, thank you.
So far from Duncan and Loosh supporting the idea that you can have a right of recreation independently of the considerations to which the Master of the Rolls drew attention, may I remind you of how he quoted from the judgments on this page. The argument on the defendant's part thus appears from the report: if this be a right of way, it is a right only of using the way for the purpose of passing from terminus to terminus, and not of walking for pleasure between the intermediate points, but the right is in fact one of a kind altogether different. It is like the privilege which the builder of a square, who reserves the centre for a garden common to all the houses, grants to the owners and tenants of the houses of walking about the garden on condition of keeping it in order. And the point made by the Master of the Rolls, at the foot of the page, is that the language of Lord Denman, the Chief Justice, involved acceptance as an easement of a right such as that which, according to our interpretation of the effect of the relevant deeds, we are here concerned. It's another case where the privacy requirement, if I can use that shorthand again, was satisfied. So far as concerns the reference to a planning condition that was made this morning, and so far as that might influence matters, Can I just call attention, by reference to page 448, that the planning permission for the villas is actually for residential accommodation. The only planning permission for timeshare accommodation was in relation to the mansion house. Small point. But in any event, one cannot allow the terms of a planning permission to influence how property law should develop in this field, in my respectful submission. It shouldn't need. So then, additional submissions in relation specifically to passivity, responding to Pomfret and Rycroft that my learned friend mentioned this morning. That is an example like Ellenborough Park itself, where the right granted did not, it wasn't of the essence that the right granted involved the continuous active intervention by the servant owner to provide the use of free facilities. That wasn't of the essence of the right granted. And there's all the difference in the world between that case and this. And the same is true of the Lock and Gate in Smith and Godmanchester and the 4 or 5 other examples that he gave, none of which take matters any further. He showed you Gale about the ancillary right to repair. Nothing in Gale supports an ancillary right to come on and operate facilities. It's a remarkable feature of my learned friend's case, that's what's involved. Operating a golf course is not a trivial matter. It requires an elaborate structure of supporting regulations and personnel to secure safety. You can't allow more than 4 people to play to tee off at any one time. I think they're called flights of players. They can only be allowed to depart at regulated intervals, because otherwise they might hit balls and injure, or even, and this happens, kill each other. Merely allowing Regency villa owners to come onto the golf course with their own golfing equipment could and would endanger all users of the golf course. You can't do it that way. And similar points can be made in relation to a swimming pool, but think of the other entries in that list of then extant facilities. What about horse riding? Haven't heard much about that. It's quite clear that more than mere passivity was contemplated at the date of the grant.
I must draw your attention, Mr. Morshead, to the fact that we have to finish at 1:30.
Well, it's been quite
I appreciate you have taken up the quarter of an hour that you gave up in your initial submissions by your reply, and I think you've just about done that now.
I have just about. Those really are the critical points that go to the heart of the matter. I think through shortage of time, I will just have to rely on the court to reread what we've written about the other parts of the case, if that's acceptable.
Well, we've plenty of reading to do.
Milady, I think there's a practice direction which says that any submissions about costs that might depart from simply costs in the event needs to be flagged up. And
well, nobody pays any attention to that.
I thought.
It's there in the practice direction, but in fact, generally speaking, if there are submissions to be made about costs, and there very frequently are, because cases are complicated and outcomes are not straightforward, then obviously they're done in writing, along with submissions about what the order might contain, depending, of course, on the outcome which we manage to work out for ourselves in due course, having taken the exam papers that you have set us. So thank you all. Court will now adjourn.